Yes! Hello, my beautiful friends! What an amazing day it is. Welcome back. I hope that your week is still unfolding oh so beautifully well. We have an amazing live stream planned ahead. We got some Supreme Court business to attend to today. Quick preview on what's coming up, and then we'll zoom in for further detail. But this is the latest filing from the Trump administration over in the Supreme Court. This is, of course, about the National Guard being deployed to Illinois and Chicago, and we have a bunch of activity on this case. So Amy Coney Barrett is getting handed this case after all of these people have filed amicus briefs. We've got Maryland, California, local governments. We got Trump, of course, Chicago Headline Club, American Rights Alliance, National Immigrant, lots of people all skidding in here. And we're going to get the latest on it because we have the reply that came in from D. John Sauer here today. So we'll go through some of that, and then we'll get some Chicago updates on this lady who was doing the old shoot in the neck thing during the No Kings protest, Maniac. Well, the school apparently has responded, and Andrew Colvette over at Turning Point got his hands on the email. So we'll look at what that is. We've got PB&J Pritzker over their governing Illinois, so-called governing. He had some comments. He was out talking to some economic club about, I guess, inheriting billions of dollars, and maybe that's his philosophy on economics. But this guy who's actually in charge out in this region is explaining that the people want law and order in their regions. And so we'll listen to Greg Bovino, the chief patrol agent who is in this region. So we'll get up to speed on what the latest is, and we'll await the Supreme Court's decision on kind of the conflict that is unfolding right now. Then we'll turn our attention to Bolton, because Bolton's lawyer, who we know is Abby Lowell, done goofed over there. Oh, Abby. And the court came out and said, you can't file your motions that way, you goof. And so he had to refile some motions, corrected motion right there. And he submitted it, and they got called out right here. You filed your motion incorrectly, Abby. So it's not a huge mistake, but we'll turn it into a giant catastrophe because we don't like Abby Lowell. And so we'll get into that. We'll have some updates on Bolton because he's filing requests to travel under seal now. He says, I was supposed to go speak over to Zelensky or somebody in Europe, and now he's asking for permission to go. So we'll go through that. We'll see what the latest is. We also had, oh yes, a request for some SEPA stuff, classified stuff. A lot of this is boilerplate, not too interesting, but since we're going to be spending some time on Bolton's prosecution, Comey's prosecution, hopefully Brennan's prosecution, and the rest of them, we're going to get familiar with the Classified Information Security Officer. So we'll go through just the highlights on this doc and see what's happening there. And before we see what the judge is ordering and hear in from Christina Bobb. Remember her? She was Trump's lawyer during the civil matters and the Florida Mar-a-Lago raid. And so she's getting now asked questions about Bolton and his classified documents. Oh, how the tables have turned. Isn't it beautiful? And so Congressman Brandon Gill was also talking about that, so he's coming up in just a bit. Then we got to turn our attention to this Nazi tattooed candidate who the Democrats love, in addition to having what they said was allegedly a Nazi tattoo on his chest, which he covered up today. This whole thing is so pathetic. We went through some of this morning, and then he went and covered it up. So here's his video of him dancing naked at his wife's or somebody's event. Some wedding. He's like, I know what to do for this wedding. Just dance naked. All right. So he's doing that. And then they released this new video, this new photo of him getting the tattoo covered up, but people were zooming in on the other tattoo. And then something interesting popped up when they looked right here. See this? Watch this right here. Look at this right here. Right next to that nip. We have a pretty strict no nip policy on this channel, but we really couldn't avoid it. I mean, I guess I could have put an emoji or something. But all right, so apologies for the nip. At least it's not Engeron's nips, okay? But anyways, he has, look at this, 1919 right there. Oh, you know what that is? Well, it might be a year. It probably is just a year, but it could also be the SS, the 19th letter. 1919 SS for Nazis. So anyways, the internet caught that and it was a lot of fun, but turns out it's probably not exactly what we thought. See, 1919, it's a Nazi tattoo. A lot of people speaking in code. And so it kind of backfired for a little bit. And the photographer had to come out and explain what it is. So we'll go through it. But the long and short of this dude is a communist. Okay. CNN wrote this article back on the 16th and they shoved it behind a paywall for subscribers only. And so we pulled it up. And he says in all these deleted posts, I got older and I became a communist. I'm like, well, all right. So maybe he's not a Nazi, although they're kind of, cut from the same cloth, both tyrannical dictatorships in ultimate practice. But he's a communist. He had all these deleted posts over on Reddit and elsewhere. And there it is. I got older and I became a communist. Like, oh, perfect. So the Democrats now they have to balance this out. Is he a Nazi, which we hate, even though we act like Nazis, or is he a communist, which we love? Oh, it's like that meme with the buttons. What do we do? So we're going to get into all of it. It's going to be a great stream. Thank you for being here. Of course, before we do get into it, let's talk about our friends over at Chapter, because it is Medicare annual enrollment again. You've probably seen it, probably gotten messages about it, not an accident. Lots of agencies and insurance companies try to make you overwhelmed. So you stop paying attention and forget about it. But Medicare plans can change every year. In 2026, Part B premiums are expected to rise by, they say, about 11%. Many Medicare Advantage plans may disappear. And that means even if you're happy with your current plan, costs might go up, or your doctor, your prescriptions, or something may not be covered. So check out Chapter right here, number on your screen. The only advisor that compares every plan nationwide to find the one that truly fits your needs. On average, people using Chapter save about $1,100 a year. That's nice. And the process is quick. So usually under 20 minutes, focused on giving you clear, unbiased advice so you can feel confident heading into the next year, 2026. So give them a call, 212-784-6742, 212-784-6742, and speak with the Medicare advisors who can help you get everything in order, our friends at Chapter. And we appreciate them sponsoring today's episode. So check them out. Links in the description below to the phone number. All right. And now, let's get to business on the day. And we're starting with the Supreme Court. Here's where we're at. The battle continues in the Supreme Court, and we have the final reply from the Trump administration, seen here from D. John Sauer, in the case brought by the state of Illinois, trying to stop President Trump from deploying the National Guard into their region. There's been a lot of back and forth on this. We've got the Court of Appeals weighing in, and just recently the Court of Appeals today, just fresh out of the oven, said that the order that blocks the National Guard from being deployed is now being extended. So here they posted over on CNN, says, and all of this is because it's contingent on what the Supreme Court is saying. Everybody's just kind of waiting around saying, what do you guys want to do about this? Because we've got some conflicts that are brewing, and we've covered this before here on this channel. The Newsom case and how he lost. And now we've got the Portland Court of Appeals in the Ninth Circuit. They lost. Trump can deploy these individuals. And we have a split over here in the Seventh Circuit. So they tell us that a district court judge, April Perry, says she's going to extend another order basically until the Supreme Court decides. And it may be coming down quickly. And of course, if you see it, let me know and we'll see what the order is. But we're still waiting. The final reply just dropped, and a bunch of people are submitting motions and amicus briefs in this one. You see, the original application for a stay came out from President Trump. They said, hey, Amy Coney Barrett, knock, knock, knock. We would like you to allow us to deploy the National Guard. Lower level judge grants Chicago and Illinois a TRO, an injunction saying you cannot deploy the Guard. They say we would like you to stop that order so we can deploy the Guard. Then we've got a couple of the application. We've got the response. Trump is going to have the final word. And so we'll look at that. But here we've got governors, Chamberlain Network, Constitutional Accountability Center, former U.S. Army and Navy secretaries and retired four-star admirals. The Steady State, Maryland is here, California, and Gavi Newsy, and the rest of them. Lots of individuals before we get to the reply that hit the docket yesterday. Chicago headline, national immigrants American Rights, Professor Martin, all of them submitting their briefings. Now, before we get to the most recent filing, here is just the table of contents on the prior two documents. Remember, we have motion sandwich. So Trump asks for the stay. Chicago responds. Trump replies. Here is Trump's original filing and just the outline, and we'll have a lot of these arguments incorporated in the reply. But they came in and they said, Supreme Court, you need to step in here because we, as the executive branch, we have the decision, the president, to call the National Guard, and it's exclusively the president's power. And what Trump did by invoking the law to deploy the National Guard, Congress wrote statutes that delegated a lot of the powers to the executive. Trump says, I exercise those perfectly lawfully. So you should hear this case because currently our rights are being violated. And if you don't hear this case, we're going to be irreparably harmed because we've got lawlessness happening there. And so accept our case. That's the long and short of the original filing. Then we got the response. So Chicago came back down, all these individuals talking to Amy Coney Barrett. They said, all right, Amy, here's our position. Brief outline. And we'll see again, some of their arguments incorporated in the reply, which Trump will be responding to all of this. So they come out, they say Trump is doing Operation Midway Blitz and deploying resources all over the place. And we don't like it because these are our illegal alien constituents. They talk about the protest at the ICE facility. They talk about how the National Guard was deployed. Then the Seventh Circuit, as we saw, entered a partial stay of the TRO, but they were ultimately enjoined from federalizing and deploying the National Guard. So they say, we're going to win, and they haven't shown that they're going to win. And they are subject to judicial review. They just can't act unilaterally, and they haven't shown that they're going to win. So because of that, you should keep the order from the lower court in place. Now we're caught up. Trump is replying with the final word. And so now all this is being passed off to Amy Coney Barrett. From the White House, DOJ, Solicitor General, Counsel of Record, out of Washington, D.C., D. John Sauer. This is the reply in support of the request to pause the lower level court that prevented the National Guard from being deployed. They tell us, all right, Supreme Court, let's be very clear about what's happening here. The president called up members of the National Guard to Illinois to protect federal personnel and property from violent resistance against the enforcement of federal immigration laws. Now, as summarized in the prior document, officials have explained in sworn declarations, among other things, the highlights, outside the Broadview facility, 1, rioters have physically assaulted federal officers. They're throwing projectiles at them. They're obstructing vehicles so that Confederates can slash the tires of federal agents' cars. 2, elsewhere in Chicago, a multi-car convoy ambushed and rammed into a DHS vehicle and tried to run over one of the occupants, while criminal gangs and transnational cartels have placed 5-figure bounties on the heads of Homeland personnel. 3, state and local officials have not only failed to provide sufficient assistance to restrain and deter this violence, but they've actually fanned the flames of hostility. They're slandering DHS agents as rogue vigilantes and jackbooted thugs. 4, just warming up. DHS and Homeland, they have been forced to divert resources from its primary target, which is immigration enforcement. Now we have to focus on ensuring the safety of our personnel and property. And 5, all of this is occurring against the backdrop of similar violence in other cities, including riots in LA and in Portland, as well as a lethal attack on an ICE facility in Dallas. Now, the president, Trump, your favorite president, thus acted well within his statutory and constitutional authority. He federalized and deployed the National Guard in Illinois based on determinations under the law. 10 U.S. Code. He says that the president made the determination that he is unable with the regular forces to execute the laws of the United States, and that there is a rebellion or a danger of a rebellion against the authority of the government of the United States because they're out there literally interfering with the operation of law. Intentionally, that's the point. Slash the tires, drain the resources. If everything's here, then you're not there. And just subvert enough don't cross the line, because if you cross the line, then you're all getting arrested and you're actually going to create sympathy for the other side. You're going to say, well, these federal agents, they're getting attacked, they're getting shot at, they're getting killed. So you would say, we got to do something about this. So they just keep it not a roaring bonfire, but just kind of, simmering cauldron. And they're waving their foreign flags around on behalf of foreign invaders. So respondents argue that the courts below properly stopped our deployment. Chicago says that the court did a careful factual determination and they made credibility assessments. Trump's DOJ says this outlandish argument illustrates the wisdom of this court's holding, the Supreme Court. In another case in Martin versus Mott, decided a long time ago in 1827, 200 years ago. Yeah, and the president's decision to call up a militia is not judicially reviewable at all. Now, respondents' efforts to limit Martin, they said, well, the Supreme Court, you already said this before the Civil War, that there was no ability for the courts to question the president's judgment, okay, judicially reviewable. Can you substitute your decision? Can you assess and analyze the president's decision? Respondents are now, okay, the state and Chicago, Illinois, they're trying to limit Martin. They're saying, well, that case only was applicable to this situation. And you can't apply that same deference in this case. And if any judicial review were somehow permitted, it would be akin to highly deferential rational basis review, which is the lowest standard as we know. We've got this low-level standard, rational basis review. Is the government law legal? Well, rational basis says if it's like reasonably related to a legitimate government function, then that's good enough. You can say it's like reasonably related. Like, oh, yeah, well, we need to do that for whatever stupid reason. That's the standard, very low. Versus intermediate scrutiny, which is kind of, a thing. And then strict scrutiny, which is it has to be absolutely necessary. And if you're going to do it, the law, then it has to be the least restrictive means necessary to achieve that very compelling interest that you have. So very high standards. So they're saying, look, even if you want to limit Martin or you want to adjust that, it's going to be like the super low standard. So as long as the president can have like an articulable basis for wanting to do something, it meets the standard. Under which Trump's determinations should be upheld, basically, if there's any plausible basis for them at all. You can't say, well, actually, I don't think that's enough violence. You just say, no, the president thinks it's violence. That's it. Like that. You don't get to substitute your judgment because, you're not the president. Not the type of second guessing, judgment substituting, effective retrial of the factual basis that the lower courts have engaged in here because they think that they're running the country. And in some cases they are. Now, given that the president possesses both the inherent authority as the commander-in-chief and the delegated authority from Congress to call up the militia, his judgment is entitled to the strongest presumptions. You have to give him the benefit of the doubt, the widest latitude of judicial interpretation that you can have. Now, as the Ninth Circuit held, and we talked about this case earlier this week, they stayed a similar injunction against the deployment of National Guard in LA. And they said, if the president's decision, if reviewable at all, like if you can even second guess it, it must be upheld over there in California. We're talking from Chicago right now, saying it reflects, you have to uphold the president's decision. Quote, if it reflects a colorable assessment of the facts and law within a range of honest judgment. That's what won in Newsom. That's what just won in Portland. Ninth Circuit, both of those cases. And the Ninth Circuit reaffirmed just yesterday, we read it too, in staying a similar injunction in Portland that the, quote, highly deferential standard bars a court from substituting its own assessment of the facts for the president's assessment of the facts because, the judge is not the president. The stark conflict between the Ninth and Seventh Circuits underscores the need for this court to stay the order below. And hopefully they do. Now, that is so even though, as respondents emphasize repeatedly, the order below is a time-limited TRO, albeit one that's going to be extended by the district court. So they're just going to keep postponing it until the violence subsides and they don't need it anymore. So this court has not hesitated to grant emergency stays before, and this relief is warranted now. This threatens the president's control over both military affairs and immigration enforcement while imperiling the safety of personnel and property. Every day this improper TRO remains in effect imposes grievous and irreparable harm on us, the president, the executive, and you, Supreme Court, should not tolerate any attempts by lower courts and litigants to delay its review through the use of preliminary injunctions issued in the guise of time-limited TROs. So the judge, well, it's just going to expire, so it's just temporary, and so you just can't come in for now, and we'll just extend it and extend it and extend it. Now, the federal government, they tell the Supreme Court, we're going to win. They came out, and they unpersuasively, they're trying to limit your prior precedent in the Martin case. You guys already said the court cannot review the president's decision to call up the militia. Supreme Court, you said that back in 1827. Just follow that. There was good logic in that decision because logically, if the courts can question the president, then they're substituting their judgment in for the president. And if you don't like that, the proper check doesn't come from the judiciary because it's a political question. It comes from Congress. It's not that the president is a dictator or a king or that he can do whatever he wants. There's still consequences for it. And the Congress can impeach the president, and they manage oversight. They can change the statutes also. They don't actually have to impeach him. Trump is using the statutory power that already exists. Congress doesn't like it, just change it. They have the original authority under the Constitution. So they, right now, could just go pass some laws. We can't believe the president doing this. But they don't. They sit there because this is what I think a large portion of the American people want. That's why Trump got elected. So to begin, respondents contend that no, that old Supreme Court case was only limited to subordinate officers and militiamen. And so certain people were discussed in that prior case. But while they try to dismiss this as loose language, they say Martin announced a broader rule from Trump's people. The president is the sole and exclusive judge of whether there is an exigency, whether we need to do this. His decision is conclusive upon all other persons, period. That's the power of the presidency. And our system doesn't work if we have, well, it's a different system. I mean, if you want to change the system, so you have like multiple presidents or somebody who's higher than the president, then you can amend the Constitution to do that. But that's not the system that we have. So pretending that a judge can override those constitutionally delegated or statutorily delegated from Congress powers is inverting the rule of law. Now, while respondents try to dismiss this as loose language, it's implausible that the court would have inadvertently used such sweeping language in this sensitive area. They're trying to water it down. And respondents themselves, the states, identify the legal reasoning in Martin that supports the broader rule that the court adopted. Wholly apart from concerns about military discipline, the court was also troubled by the possibility that in suits for damages, the existence of the exigency and what the president decided would be upon stuff submitted to a jury. And they say it's just as troubling like this one that the legality of the president's orders would depend upon proof submitted to the court rather than the president's own judgment, right? So now, like, the courts are not, the executive branch is set up to run the country. That's why the president gets data from all of the intelligence agencies and all of his people. And this is in the Constitution, that the president executes the law, right? It's the structure. So if the court then wants to subpoena a bunch of stuff and investigate all of his decision making and say, well, actually, I want to subpoena this person and get declarations from all these people and what's really going on and all these things, then the judge is acting in an executive function and eventually going to substitute her judgment or his judgment for the president's to say, well, based on what I've gotten from all these materials, I don't think that it meets this standard of rebellion, right? And she'll make that decision. It's not her decision to make. Congress passed the statutes and the Supreme Court found accordingly. So indeed, it's arguably more troubling because an injunction thwarts the president from taking the necessary military action, and a damages award indirectly deters the president from doing that as well. Now, the states, they come in and they attempt to limit Martin to the British invasion of the United States during the War of 1812. But that makes even less sense. Not only did the court decline to narrow its opinion in that matter either, but there was no reason to hold that the president's decision was unreviewable only because it was obviously correct. In other words, the whole point of resting on unreviewability rather than on the merits is because even when the merits are clear, it's to preclude review in future cases where the merits seem less clear to the courts. So like, well, obviously like he could use this law in the statute in 1812 because it was an invasion and we were under attack. There was rebellion and the British were coming and all the things. But that's sufficient to meet the standard here. So we don't really need to review that. And they're saying, well, so it's unreviewable. That's the point. Just because it happened to be good and you're happy with that, the decision, doesn't mean that you can review it. It's unreviewable either way, if it's good or you think it's bad. It's up to the president, and then there are other checks on the president. So subsequent precedent confirms this broad reading. In fact, in 1849, another case called Luther versus Bolton, the court analyzed a different part of the law at issue in a different context. This involved an armed dispute between domestic factions claiming to be the legitimate government of Rhode Island. And it reaffirmed the precedent that when the president calls out the militia, that decision must be respected and enforced in judicial tribunals. Luther, again, it confirms that the prior Martin case doesn't turn on the challenger seeking review to say, well, I don't think you needed to do this. And that's how these have traditionally been understood. The president's decision in this area is absolute. And for instance, a report prepared by the Department of War back in 1903, the same year that Congress reformed the National Guard, they cited both those cases, Martin and Luther, saying, yeah, the president is the sole judge of the exigency. The judge doesn't get to say, well, actually, I think it's not an exigency, in determining whether a domestic disturbance justifies federalizing state militia. Further undermining their position is this court's description of Martin outside the military context. In fact, in 1962, we had another case called Baker versus Carr. This is one of the leading political question cases involving a political determination where the need for finality was dominant. And fast forwarding, even in cases where the court has reviewed executive action, it has distinguished Martin as involving action which appropriately belonged to them and is not the subject of their judicial review. And it's not that the courts can't do or check the executive at all. It's just that certain powers, like this one, are beyond their scope. Respondents fare no better in arguing that the law from Congress does not expressly provide for the decision or that it's committed to him. For starters, the statute in Martin also did not contain that language, so it's not exactly any different. But Martin said that the true construction of the statute was that it conferred a discretionary power to the president. And that same rationale applies here. The power to call up the militia is confided to the executive, who is, by the Constitution, the commander-in-chief, whose duty it is to take care that the laws be faithfully executed, and whose responsibility for an honest discharge of his obligations is secured by the highest sanctions. So in other words, because it would be difficult to think of a clearer example of the type of governmental action that was intended by the Constitution to be left to the political branches that are responsible, the statute should be understood as implicitly vesting the determination in the president's decision rather than allowing some judicial second guessing. Lots of case law. George S. Bush and Co. 1940 case. When in the president's judgment, it's the president's judgment. It's the discretion of the president. And this is also because the president is constitutionally accountable to the people, elected by the people. Congress can impeach the president. There are consequences. Congress can exercise oversight over that person. And there are political questions that are being proposed and answered. And the courts are not set for that. That's not their job. So it's delegated to the president for that reason. If Congress wanted to, they could say, well, how about we just, for every deployment of the National Guard, we, try to create a body or something, we'd say those are unconstitutional too. But, they could set up some other framework. They didn't. They delegated it because that's how the Constitution works. Now, indeed, respondents provide no reason to believe that the courts can or even should second guess the president's conclusion that there is an actual invasion or rebellion, or that he can't execute the laws of the United States. In fact, judicial inquiry into these matters involves an area of governmental activity in which the courts have less competence than the political branches. They're just not good at doing it. For example, they say that the evidence shows that Homeland has managed to carry out its mission in enforcing immigration law. They also point to the number of arrests to say, well, you don't actually need to federalize anything. But their argument that we have made a sufficient number of arrests is doubly problematic. It runs up against the Article 2 authority to enforce federal law. And you, the courts, generally, citing another Supreme Court case, this one, U.S. versus Texas in 2023, courts generally lack meaningful standards for assessing the propriety of enforcement choices. Okay, it's not their job to set those standards. So in some Supreme Court, Amy Coney Barrett, this case falls in the heartland of unreviewable presidential discretion. They claim that there was nothing in the conditions at the time when Trump federalized the National Guard that justified doing so, right? And we saw this in the Portland case where the lower level judges just tried to limit it. So they went to the date that President Trump issued the order. And they said, well, on that day, it was a sunny 75 degrees out, not a raindrop in sight. It was beautiful. And the protesters were out, hungover at home or whatever. And so you didn't need to deploy the National Guard on that day. It's like set like a 4-day window. Okay, so you just forgot everything that happened for the 3 months before that, and you're forgetting everything else that happened after that? How convenient is that? So they're trying to do the same thing in Illinois and Texas. Illinois and Chicago. But as the contention at best concerns not a want of power, it's clear this is beyond the reach of the courts. But if it is reviewable, if you can look at this, and courts, they don't really like to give up any oversight. So I think we might see the Supreme Court not go this far ultimately, but to say that there's a lot of deference. There's a lot of benefit of the doubt, good faith given to the executive branch because the courts are just not set up for this. And they are usurping the presidential power. So they say, well, if you think you can look at it, Supreme Court, which they probably will, because again, it's like their power. I'm not going to say, do whatever you want. Such review must be extremely deferential if you're going to look at it. As the Ninth Circuit has recently held in those cases, we got LA, we got Portland, we talked about those. The president's decision, according to them, must be upheld at the very least, quote, where it reflects a colorable assessment of the facts and the law within a range of honest judgment. So it's like, if you can just make an argument for it, like that sounds plausible. I disagree with it, but all right. It's good enough. And this highly deferential standard prohibits district courts from conducting their own evaluation of the level of violence necessary or the impact on the execution of federal laws. Like, well, it's not, you're still deporting people, so it's not stopping you, so it's not that big of a deal, so you can't deploy anybody. Or substituting, quote, their own assessment of the facts for the president's assessment of the facts, which they love to do. Under that standard, Trump's deployment of the National Guard to Chicago fell well within the authority vested by him under the law about the inability to execute the laws and the danger of rebellion. And so he's fine even if you do look at it, but you can't. Now, they claim that the Seventh Circuit applied the better standard, the preferred standard for whether regular forces are unable to execute the laws merely because the court found that Homeland was, quote, not significantly impeded. Okay. The building didn't actually burn down. So they just had to barricade it and, evacuate everybody just a couple times, whatever. But it's not significant enough. So I'm going to say no guard. They appreciated that standard, but in construing that standard, the Seventh Circuit applied a de novo review, meaning we're going to look at it brand new, fresh, holding that the president is not entitled to deference on the meaning of the statute. Okay, so Trump can come to a decision They're not questioning that decision. They're just questioning the statute. See how clever lawyers are? Unlike the Ninth Circuit, then the Seventh Circuit, they failed to defer to the president's colorable assessment of the facts and the law, which they cited in the Ninth Circuit in Newsom. So we've got a split that is developing right now. Seventh Circuit says the statute has not been met, just kind of basically inverting the argument. And the Ninth Circuit is saying you really can't question the facts or the law. I was like, well, the law says something and the facts don't meet the law. Okay, so you're kind of judging the facts in that equation. Now, in particular, the Seventh Circuit held, well, they're not even significantly impeded in enforcing federal immigration laws because they still proceeded right there. Oh, they're still deporting people, so you're fine, you're good. It's like you're bleeding out, but it's like you're still alive. You can still walk. Like, just walk it off, you're good. They're like, they're shooting at us. Yeah, but they're not hitting you, so what's your problem? Just, go about it. Oh, they're trying to kill us, but they haven't killed you yet. Okay, come back to my court once you're dead, and then we'll talk about it. Says, have remained open, and violent resistance is being contained by federal authorities. But none of that remotely means that immigration enforcement has not been significantly impeded by the violence. They completely ignore that Homeland agents would be able to engage in greater enforcement of immigration laws if we're not operating under threat of assault and obstruction, and that they're currently bearing unacceptable risk to their safety while doing their jobs. Now, the president and his determination that this constitutes a significant impediment is correct. And at the very least, it's colorable, and you don't get to substitute your judgment for that. Respondents likewise ignore that Homeland has managed to achieve the results it has only by undertaking the extraordinary diversion of personnel to come over and help to protect them. The Ninth Circuit also held they rejected a similar error in Portland by that judge and discounting that the surge of officers was inherently irregular. If you have to deploy additional people just to do your standard job, then that's not the normal. That's irregular. That shows that the local cops can't keep up with this, so feds have to come in to help. And fixating on what that irregular surge facilitated, the district court afforded no deference to that. So the other judges reversed it. They said, there aren't any problems. You just brought all your other resources over here. And they say, that's the problem. We had to bring resources over here. So now we're going to bring the National Guard over here. Thank you for making our point for us. But they also improperly try to dismiss the violence that they have faced. They double down on the lower court's decision to deem Homeland as unreliable. Homeland declarants, are unreliable. They say, well, we don't really believe you. You work for Kristi Noem, and so nothing you say matters to us, based on a credibility assessment. But when courts substitute their own determination of facts and circumstances, that is exactly the opposite of reviewing the determination with great deference. All the more so here, given the baseless nature of adverse credibility findings. Based on what? They continue to emphasize that grand juries declined to indict some of the assaults of federal agents highlighted in the declarations. And why would they? It's their people. They created a sanctuary city. You try, and then they can attack federal officers. Then you try to indict those people, and they have a jury of their peers, other people who would also attack federal officers if they could. So you can't get indictments. And I guess that's supposed to be America, where now you can have illegal alien invaders can take over the entire cities and attack federal officers, and you just have to sit and deal with it, according to this judge. And if the federal officers come in and say we're being attacked and local law enforcement aren't helping, the judges say, we don't believe you. The district court itself admitted the assaults occurred and that there is an obvious risk of grand jury nullification in some cases when state and local leaders publicly malign Homeland officers as jackbooted thugs and rogue, reckless group of heavily armed and masked vigilantes. Indeed, respondents even try to impeach one of the declarants based on representations made in another case that the district court here never even relied on. Likewise, the states minimize much of the violence, and the lower courts are just ignoring it. They describe the coordinated ambush that rammed a Homeland vehicle and tried to run over its occupants as, quote, an isolated incident. It's just an accident. He made the wrong turn. It was resolved by law enforcement. And they also treat, quote, similarly, the bounty placed on the head of a senior Homeland official by the leader of a Chicago gang. Not a big deal. The Ninth Circuit, though, recognized. They said the president can consider the totality of the circumstances, and it's error, like these courts, for you to discount evidence that you think is not relevant. You're not the president. That is especially so here, where the events in Chicago are not occurring in a vacuum. Violent riots have occurred in LA and Portland. A shooter tried to murder federal agents in Dallas, and Mexican cartels are placing bounties on Homeland personnel. Now, finally, the states assert that local law enforcement officials responded to every call for service they received. In addition to being legally irrelevant for the reasons discussed, that assertion is factually belied on the record. For example, when a crowd of approximately 200 rioters surrounded Homeland agents after their vehicle was ambushed and rammed, Chicago police took more than an hour to respond. In part because, as a screenshot of internal dispatch even shows, they were initially ordered not to respond by the chief of patrol. Nope, don't go. Just let the attacks continue. Likewise, after ICE officers made 3 separate phone calls to the police for assistance on a day when rioters threw rocks near the facility gates and damaged 12 vehicles, the Broadview Police Department told the officers that it would get back to them and then never responded. Now, the states also contend that a rebellion under the law must oppose the laws and authority of the government as a whole. Emphasis added, as a whole. But while they cite various dictionary definitions, they admit that other dictionaries define the term broadly enough to reach opposition to particular laws. And their attempt to use statutory context to resolve this issue gets things backwards. After all, they do not even dispute that one of the earliest and most famous uses of the militia to put down a rebellion, the Whiskey Rebellion, involved violent protest based on political opposition to the collection of a particular federal excise tax. Now, they observe that the statute invoked there did not use the term rebellion, but provide no response to the point that later enacted military statutes referring to a rebellion were obviously intended to cover this historical precedent of violent opposition limited to particular federal laws, which is exactly what's happening here. They're mad about immigration. So when you make that argument, they say, well, rebellion means like you have to want to overthrow America, which do they not? Many of them? Respondents thus retreat to the position that the violent opposition to the federal immigration enforcement is not sufficiently organized, and it's not avowed to constitute a rebellion. It's just kind of a theory, you know. And if they get too organized, then it becomes a real thing. So everybody just, no, it's not just an idea. It's an abstract concept. No organization at all. But that fails to defer to the president's assessment. Given the various and coordinated assaults on Homeland agents, the threats posed by criminal gangs, the climate of violence in cities across the country, the president had ample basis for determining that there is at minimum a danger of rebellion. At minimum. It may not be an active rebellion, but there's a danger of it. They have foreign flags, and they're fighting for their constituents against the lawful enforcement of the law. Then they talk about the 10th Amendment claim. They say it's also meritless, Supreme Court. As the Court of Appeals recognized, their 10th Amendment claim rises and falls with the statutory claim. But they nevertheless contend that the federal government violated the 10th Amendment by using the threat of federalizing the National Guard to deploy these people to Illinois. But if the president had the authority under the statutes to federalize the Guard, then his offering not to exercise that valid authority is a form of federalism that is permitted by the 10th Amendment. And so you need to hear this case, Supreme Court. The states do not seriously dispute that whether a district court may enjoin the president to put down violent resistance is an exceptionally important question that warrants this court's review, even in the absence of a circuit split. And regardless, there is a circuit split because the respondents are incorrect. The 7th and the 9th circuits, they did not disagree when they say that they did not disagree that they're incorrect on any aspect of the legal analysis. They say that's not true. As noted, In the Ninth Circuit, Newsom deferred to the president. They said there, the president's colorable assessment of the facts and the law. If the president can make a good basis for it within the honest bounds of judgment, you can't second guess it. The Seventh Circuit, though, by contrast, they said that the president is not entitled to deference on the meaning of the statute. So one says he gets deference on the law, the other says he doesn't. And that affected how it construed the significantly impeded standard and whether the forces are actually unable to execute the law. Then the Ninth Circuit in Oregon, they said that it was error for the lower level, talking about the Portland case, it was error for the lower level judge to substitute her judgment of the facts and the circumstances. And the Seventh Circuit said it was not clearly erroneous for them to do that. Okay. In Chicago, Seventh Circuit, you can weigh some facts. You can make judgments on credibility, but in Portland, in the Ninth Circuit, you can't. Nor can they evade this court's review. So like this is Supreme Court, you got to settle this because we got a real big split happening. Nor can respondents evade this court's review, the states. They don't want the Supreme Court to accept this. They say, well, it's going to expire 2 days from now on October 23rd. They acknowledge that they are going to hold a hearing in another 14 days to talk about extending this. And this court has granted emergency relief before for very similar matters like this. You should do that same thing here. Every day that passes is another day where a federal district judge has usurped control of military forces from the commander-in-chief, imperiled the safety of federal personnel and property, undermine the enforcement of federal immigration laws. If you, Supreme Court, allow this egregious order to evade review, it would invite other lower level courts to try to insulate their injunctions by granting 14-day TROs, knowing that the Supreme Court will say, well, it's going to be moot. It's going to be expired soon, so denied. Then they're just going to extend it. We would have to restart the entire process. That is going to guarantee anarchy. And so, Amy Coney Barrett, please accept this case. They repeat many of the errors above in arguing that this doesn't irreparably harm the government. First, they say the TRO is going to expire, but we're already having serious harm. And there's going to be an extension, no doubt, and then followed by an equally harmful injunction absent a stay by this court. And the court basically did extend it already. Now, second, which as we saw over here in this filing, she will extend the order through final judgment. So it's already been extended. So like, yep, told you. And they're telling that to SCOTUS. Second, the states also contend that the Seventh Circuit has already partially stayed the TRO already, but they disregard that allowing the guardsmen to be federalized while continue to bar them from actually being deployed is the point. It nullifies the purpose of this, which is to actually send the troops over there to protect federal property. So, okay, Trump can federalize them, but they can't be actually used. So that's why the Supreme Court shouldn't hear it because it's already rectified? No, it's not. Respondents also, the states, contend that the lower level court found that the federal government can do their job. They have been able to perform these functions, and so they don't need the National Guard. And so I'm overruling you. But that improperly substitutes the court's factual assessment for the president's. Now, conversely, there are no harms, no cognizable harms from staying the TRO. They say, well, you're going to hurt our sovereign interests because we have the right to deploy our own guard. And they say, it all depends on the government lacking its own sovereign authority, but they fail to address the government showing that this rioter's veto is legally meritless and factually baseless. And so in conclusion, Supreme Court, stop the lower level court's order, the one that came out on October 9th, grant a stay if necessary, and allow us to deploy the guard to save our cities that have become sanctuaries for foreign invaders in America, who are then commandeering power and essentially taking over the courts. Supreme Court now going to be receiving this case, and we'll see what they do with it. But speaking of Chicago, we had PB&J Pritzker out here basically calling the Republican Party and the Trump administration Nazis. Here is a short clip.
We have to save this country from what Donald Trump is doing to it, because no, I do not want this country to become like other authoritarian regimes. People have criticized me for talking about the Nazi regime. On the right, people have criticized me. It's the one I know most about because I helped to build a Holocaust museum, and I can tell you, sitting next to Holocaust survivors, that what they will say in this moment is, this is what happened. This is what happened. People's rights started getting taken away. People got accused of being immigrants. This is before the Holocaust really took place. People were accused of being immigrants, and then laws were passed to limit immigrants, and then people who weren't actually immigrants were called immigrants, and then it was othering people, and that led to a lot worse things. What I'm saying is that this is how authoritarian regimes do it. They create these kind of fake ideas that there's an enemy out there and it could be sitting next to you at one of these tables. And so just somebody...
Yeah, and we made this point this morning on the members only live stream when we watched this, but we also know that many of them are sitting next to us. Firemen, nurses, doctors, surgeons, politicians, teachers, all salivating and celebrating the death of Charlie Kirk. College kids right next to your kids, screaming, "More dead fascists, please." Attorney general candidates running, talking about murdering their kids of their political opponents. The list goes on. And that's communist subversion. And another tool of an oligarchical class is to wreck the nation by having it invaded by foreigners so that that new constituency can replace the old constituency and they can be the leaders of that new conglomerate, which is exactly what's happening in Chicago and Illinois, which is why they're so offended by the deportations that are underway. Now, somebody else in Chicago was this woman, this lunatic, who was mocking and mimicking getting shot in the neck during their No Kings rally in America. Andrew Colvette over at Turning Point, Charlie's colleague, he said, a parent from the Nathan Hale Elementary School in Chicago, where Lucy Martinez, the neck lady, giant neck lady, she remains employed, just forwarded this email to us from the school principal, Ilis Gomez. The parent is livid that the school is making Martinez out to be the victim and even acknowledging her vile behavior. They say it's simple. Nathan Hale and Principal Ilis Gomez fire Lucy Martinez for mocking Charlie's murder and the attention will subside. We will cheer you on. She failed life's pop quiz and has no business being around children. Okay? Literally teaching your kids. Yeah, getting shot in the neck like a lunatic. Here's what the message said from the school. This is their message out to everybody. The dear Hale families and staff, safety continues to be my top priority, which is why I am writing the follow-up on a situation regarding social media posts that included potentially threatening language to a staff member. She's the victim. The Chicago police is continuing to investigate this situation and will continue to provide our school with extra support during arrival and dismissal until that investigation is complete. I know that this has been an unsettling day for many in our school community because your teacher is a lunatic, but I want to assure everyone that learning is continuing to move forward for all students. Our school day was uneventful, and we look forward to welcoming all of our children back to class as normal tomorrow. I apologize if anyone had trouble getting through to our main office by phone today. Many calls are coming in from beyond our school community, but we hope that these will subside soon. In addition, our school's website and X account remain paused. They nuked them like immediately due to the use of inappropriate language by individuals not connected to Hale. These will be restored as soon as we feel that it is in the best interest of our school community. I thank you for your support and will continue to keep you updated with regard to the investigation of this matter. Sincerely, Principal Ilis Gomez. So they've gone dark. You can't even look them up, right? All of the websites are pulled down and they're victims. And she probably is still teaching people, still teaching your kids. So Pritzker says that we make believe that there's psycho lunatics out there who are celebrating murder and death presumably wanting more of that. That's what you're mocking. You're saying, yeah, he deserved it. He got it. In the schools, teaching the kids. So Pritzker, he can eat that too, which I'm sure he will. So we've got that. We also saw the actual people on the ground, Greg Bovino, Chief Border Patrol Agent. He's explaining we're actually doing good stuff. Johnson and the rest of them are catering to their illegal aliens, but this is America, and the deportations will continue.
He says that you all are terrorizing working people. What you're doing is unconstitutional. How do you respond to the Chicago mayor?
Mayor Johnson is so out of touch with his inner city. We talk with the inner city residents on a daily basis. They're glad we're there. And as far as terrorizing, if you're a criminal, illegal alien, or an illegal alien, then you're going to go to jail and be deported. You have the opportunity to use the CBP Home app, free plane ticket home and $1,000. That's not terrorizing. That's giving folks a chance to do the right thing. If they don't do the right thing, we'll arrest them. And if Mayor Johnson equates that to terrorizing, then that's his fault for, as you say, Sandra, amping up that rhetoric, which often leads to violence against law enforcement.
He says
it
that
does, and that's kind of the point. They want to interfere with their operations so that the deportations can stop ultimately or come grinding to a halt. And the more resources that they require to be expended in Chicago and LA and Portland, then the less they'll have to conduct those deportations at scale. So Supreme Court is going to have to weigh in on this. Of course, we'll keep our eye on it as Amy Coney Barrett takes the final reply over to the court. We'll be here continuing to cover it. Thank you for subscribing and joining as we do. All right, now, my friends, let's talk about Bolton because we have this one. John Bolton's lawyer, Abbe Lowell, screwed up. Here you can see the court called him out. Abbe came in and he said, I'd like to file a proposed sealed document entered in there. And what we know now that we have the corrected filing is that he wants to leave the country, looking to go on a little speaking tour over in Europe or something. And so we've got the final document that came out here, and we'll look at what's going on, the latest with John Bolton's case, because the government is also now disclosing some of their classified information procedures over to the court, hoping the court will start to set the rules on this so that the discovery process can continue. We're talking about national security documents from John Bolton's wife and daughters and their home and email accounts that were hacked by the Iranians. So here is what Abbe Lowell did. And Abbe Lowell represents some of the worst Democrats, largely. Letish James, he represented Hunty Biden. He's representing the fired CDC lady. John Bolton is just the latest addition. And I think there's even more. But he came in and look what happened. He submitted this and the court came back and they said, Abbe, your motion to seal was filed incorrectly, idiot. Motions to seal may not be filed under seal, you big goof. You must refile the motion publicly. So John Bolton's in big trouble, I think. So, you know, classified documents and he's normally not handling these cases because Hunter Biden was a crackhead and didn't get prosecuted for those gun charges and tax charges. And he lost for those. Oh, Bob Menendez was the other one that Abbe Lowell represented. He's going to prison. Hunty got pardoned. Now John, he's like, wait a minute. You filed a motion to seal under seal? I'm going to jail. So here is what the actual motion said. And it's not really that big of a deal. It's just a filing, just refile it, do it, click the forms differently and resubmit it. But Abbe Lowell's a piece of work. So we make much ado about it because of course we do. Now here's what the motion actually said from John Bolton. He wants to go on a little trip. Defendant John Bolton is now filing his request for international travel, and he wants to submit the actual motion under seal. This is permission to file the other one under seal. So Abbe, he came back out and he submitted this one. He's like, oops, resubmitted it. He says, here you go. John Bolton is now asking this court for permission to go on international travel. Pursuant to the rules, We know that his conditions of release that we talked about require approval in advance if he's going to be traveling outside the continental United States. Now, as indicated by Ambassador Bolton's counsel during his initial appearance, he was previously scheduled to go speak at a conference in Europe in early November 25. Wonder what that is. Good cause exists to allow Bolton to file this request, which includes detailed information about his upcoming travel, itinerary, all those things under seal. Now, Bolton has previously been the subject of credible safety and security threats. For example, in 2022, a member of Iran's Islamic Revolution Guard Corps was changed for attempting to arrange the murder of Ambassador Bolton. Then they hacked his emails, and he didn't tell the FBI about it. He continues to face such threats and requires around-the-clock security protection. Yeah. And I guess they'll go overseas with him. So he seeks to provide the court with sufficient details about his proposed travel. And if he publicly files that, we're all going to know that he's going to go meet with Zelensky or Macron or somebody. Accordingly, Bolton respectfully requests that you allow us to file this under seal. And of course, the court is going to allow that to happen. And he will submit it. And I'm sure the court will approve it. But we don't have any decision as of yet. Now, the DOJ also submitted some other documents. A lot of boilerplate language in here, but we'll just look at the structure so we can see what's going on in this case, which is why this case is, going to probably drag on for a bit, just like we saw in the Mar-a-Lago case, because they had all these classified documents, and then we have CIPA, the Classified Information Procedures Act. Now they're talking about the need for a pretrial conference and the appointment. This is from the DOJ. And Lindsay Halligan coming out of not Lindsay Halligan. This is coming out of the District of Maryland. We'll find out who wrote this. But this is, as you can see, a lot of kind of, legal heavy lifting. So definitions, how it all works, how appeals work, what the security procedures are, how to actually identify information, what the process is for protecting all of this during discovery. We're obviously going to have to disclose this to John Bolton, how you can appeal this stuff in the middle of the case, how that works, a protective order for all the documents, a request for a pretrial conference. So a lot of the technical stuff, because John had 18 counts of classified materials, which is not good. Now, this prosecution involves the unlawful transmission, communication, delivery, and retention of national defense information. We've already determined that we got to give some of this stuff back over to John. And at least some of these documents will comprise part of our proof at trial. So we're going to give it to him and use it. We also anticipate that we may need to make certain pretrial rulings to discuss the actual evidence. And so accordingly, the Classified Information Procedures Act, CIPA, will play a significant role in this case. We filed this memo to let you know about the procedures and how we think we should handle all of these matters. We also ask that you appoint a security officer to handle this stuff and set a pretrial conference at the same time as the initial status conference so that we can get into the nuts and bolts of this. So here's the background. John Bolton, charged, 18-count indictment, willful transmission and retention of classified information. Speedy trial says the trial shall commence on or before January 30th. And the clock is ticking, but I do believe they just waived some of that. I think I saw an order for that. Maybe that was a different case. Yeah, consent motion to exclude time. So that date may be changing as well. But anyways, so here's more. They've got this here. Classified information, including the national defense information that, in other words, I'm not sure that this case will actually go on January 20th, 30th next year. James Comey is also set. And we haven't seen the classified stuff happening there yet. So we'll see. Anyways, so that's coming up quick. That's going to be here before we know it. Anyways, classified information, including national defense information. He's charged with retaining a bunch of these things. And CIPA needs to come in because if we disclose this stuff to him, it's going to raise issues of national security. And so the rules authorize us to ask for a pretrial conference, which is what we're going to do. Now, a lot of this case, just background stuff, overview of the act. Congress passed this puppy in 1980. It doesn't change our discovery obligations. It doesn't alter the rules of evidence. all it does is mandate a number of procedures at pretrial, trial, and appellate stages of the criminal case to balance the defendant, in this case John Bolton, and his rights to due process, including the right to a fair trial, against the government's interest in protecting classified information, sources, and methods. This interest applies in both discovery and trial contexts. And the Supreme Court has weighed in on this. They know we got to protect the nation's secrets from disclosure, which, I mean, everything is secret. You know, we know nothing about stuff we should know about. But all right, in this case, it's secret. Fourth Circuit has also stated that CIPA gives district courts wide latitude to handle these matters. The U.S. may produce discoverable material to the defense, and we want to make sure that it is protected. And so accordingly, you can assess to what items classified information procedures should apply. You must go through this procedure, right? Is this discoverable? Is it something that we can pass over? The court must assess if there's privilege over it. And third, the court must consider whether it's even relevant. Is it even helpful to the defense? Classified information that is not helpful may be deleted. That is, it's withheld from discovery. They can't even see it. We saw that with Trump. Classified info that is relevant and helpful must be produced to the defense. And so the defense might say, that is going to be helpful to us. Like, we want that. We might use that. The court says, well, you can't use it because it's not actually helpful. And this could actually have substantially the same ability to make his defense as would disclosure of other information. So they give us definitions here. Comes out from these statutes. Pre-trial conference, you're allowed to ask for one. They ask for a protective order. It says the court shall issue a protective order following the rules. And there's a lot of details, okay? Protection of information during discovery. And it just kind of goes on and on. We'll fast forward through a lot of this. If you determine, judge, that the information that's classified is either not relevant to the determination of guilt or innocence, or if it's helpful, you can withhold disclosure of that information, which as a defense attorney, you're like, I want it all. I want everything. CIPA also says that the government may demonstrate that the use of alternative discovery like deletion or substitution is warranted. A security clearance at a given level is not sufficient to entitle any individual to access that stuff at that level. Rather, the courts can make that determination whether it's need to know. Need to know as defined as a determination within the executive branch that a prospective recipient requires access in order to perform their lawful functions. And a defendant, in this case Bolton, may be entitled to notice when the government initiates CIPA proceedings, and there is no due process right to receive a description of materials that are not discoverable. Okay, so you can't use it as a tool to pry in to get classified material. Sorry about that. Only if the information is discoverable must the court then examine if it's also helpful. And there are three critical steps to this. They got to specify the info that they want. The court then has a hearing, and then we talk about the admissibility of the evidence. And third, following the hearing, we may substitute other materials. Like, we don't want that actual document. We just may make an admission, a proffer. And the defense has to disclose stuff too. If they fail to provide notice far enough in advance of trial, then they just lose the right to do it. They don't get access to it. These are not set up to help the defendant in any way, shape, or form. I mean, there is some access and ability to it, but these are highly in favor of the national security secrets, as we saw with Trump. We're like, he was the president. He saw everything. Like, sorry, you can't see it again. Any hearing in this case shall be held in camera. That is, in judges' chambers at the request of the AG. In connection with the hearing, the government may submit an affidavit from the AG saying that if you disclose this, right, so the Attorney General, Pam Bondi, can step in and say, nope, you're not going to see it. There's identifiable damage to national security, and so the defense can't have it. Then the court can look at it, and the court shall seal and preserve all the records. Because we can't see anything. We're just citizens. We're like peasants, you know. If the court determines that an item of classification is relevant and admissible, the government may object to the disclosure, and then they may issue an order to the defense, don't disclose anything. Now, you might also want to appeal this. So, like, if there's a bad ruling, this is how the appeal works in the middle of the case. Don't have to wait to the conclusion of the case. If an appeal is taken, trial doesn't commence. It pauses everything while you appeal this disclosure. Bolton says, I need that. Government says, no, you don't. Appeal, fight over it. Everything pauses until we're back down. Section 8 then is about introducing materials to prevent unnecessary disclosure. This permits a court to order the admission of evidence, only part of it. So you don't need the full document. You can just submit portions. And if you need to do an examination, the government may be able to offer a proffer. There are also security procedures that they should go to, and the government is now making the request. So we're in the process, writes Maryland, of identifying and reviewing material that is currently classified. Some of this material may be subject to disclosure in advance of trial, could raise national security concerns. And so we respectfully ask that you schedule a pretrial hearing to go through these issues, and we'll give you an update how much time we think once we do our work. Because of the nature of this, we can't give specifics in open court, but we could do it ex parte in camera in an in-camera hearing. So only the judge and the government in the judge's chambers off the record, behind closed doors. As previously noted, the courts have consistently held that these are proper. We also want a security officer to come in. And here are the people that are available. Bunch of names listed here. A proposed order is also attached. There's going to be a bunch of classified stuff going back and forth. And so we need a hearing and we need an officer. This is in the Bolton case. And the judge is granting the speedy trial. Yeah. So here, the time from October 17th shall be excluded. And so we're just keeping our eye on the dates, the next dates that are coming up. But you remember this woman, Christina Bobb. She was Trump's attorney and highly involved in the Mar-a-Lago case. And she was asked about John Bolton since she's got experience with classified documents prosecutions on the receiving end. Here's what she said.
How much legal trouble is he in?
A lot. I mean, I can tell you as a criminal defendant myself, any criminal case is a lot of legal trouble, but 18 counts violating unlawful disclosure and retention of classified materials is nothing to laugh at. It's far more significant than what they charged President Trump with. President Trump was supposedly obstructing justice when they were trying to investigate him. I mean, they have 39 counts of that. They never once alleged that he unlawfully gave anybody else access. They were just saying that he was sloppy in how he maintained his records and he obstructed justice was basically the allegation, which, no victim, right? But with this, they're saying that he was actually disseminating classified information. And I will also highlight that this comes from a Maryland grand jury. This case is filed in Maryland, which is a very liberal district. So he has a favorable jury pool and they still found enough probable cause to indict him.
And speaking of liberal grand juries, and look, this is why I say to the Democrats, relax. The grand juries are coming from Maryland, from dark blue Northern Virginia, where James Comey was indicted for lying to Congress. Tish James was indicted for mortgage fraud. I mean, that's how the system is supposed to work. The grand jury takes a look at the evidence presented. They make a decision. Usually it's about 25 people. You never know who, and they never disclose the conversation. But that's why the system is in place, to make sure that people that get indicted for the right reasons, correct?
100%. And they're trying to sway the courts through the media, through the court of public opinion. They're trying to muddy the waters enough because they know that the Trump Department of Justice can get convictions on these because there's enough evidence to actually get convictions. And so they're trying to foment enough discussion about this negatively towards the Trump DOJ to try to get the courts to throw the cases out because they have liberal juries. They also have liberal judges in these areas. And so they're trying to create enough of a shield for these judges to dismiss the case. If the judges follow the law, the cases should not be dismissed, as far as I can tell. There hasn't been anything that I've seen reported that's improper about any of this. But I mean, it's a battle. The venues for all of these is against the Trump DOJ.
Yep. And now Bolton is having to face the music. And Bolton was one of those guys who was repeatedly out on the cable saying anybody who did anything bad with classified information should even in some cases get the death penalty and be locked up forever. He was very excited about that. So Brandon Gill, another congressman, he posted this one today. He said, Bolton was entrusted by the president to handle classified information appropriately. And if he's found guilty, he should be held fully accountable. Brandon Gill, congressman, saying the following.
It seems like the Biden administration recognized that John Bolton was a critic of President Trump, and they didn't want to bring charges against somebody who was attacking at that time their political opponent. That seems to be the politicization here. Listen, these are very serious charges. This is information that can get people killed. This is government, military-related, national security-related information, and we've got to take that seriously. You know, I think we've gotten a little bit lax in certain areas about where classified information, top secret information goes, and this is somebody who is entrusted by the president and, by extension, the American people to deal with this information appropriately, and it doesn't look like he did.
Yeah, and that is from Brandon Gill. And what John Bolton did was a plot. Before he even came in, the day before he got the job, he was creating this little group chat with his wife and daughter and then exploited that the entire time, all with the pretext of writing a book. Who knows if that's true? He definitely did write a book and it was filled with classified information, but is there anything else there that went on? And the guy also sent classified documents and materials to himself via email to AOL, an AOL account that the Iranians hacked. So every criticism that he lobbied against Trump and others, he was the one committing, which is the standard for many people who are part of the deep state operation. I was going to say Democrats. He became a Democrat adjacent individual, but they commit the offenses and then accuse everybody else of committing the offenses. And in many cases, will prosecute them and try to imprison them for that. And John Bolton was never the president. So we'll keep our eye on this one. We'll hope that his lawyer learns how to file documents appropriately so he doesn't have to get scolded on the public docket. But Abby Lowell, not off to a great start over there. All right, so we got one more story, my friends. And then we'll hear from you. The Democrat Nazi tattooed candidate is having a tough time. He covered up that symbol that was on his chest that many people were talking about, courtesy of this video. And this was apparently at a wedding. He said in a podcast that he was doing this little dance thing to embarrass everybody, which is a strange thing to do, to get naked at a wedding. But in addition to being naked at a wedding and, you know, dancing drunk all over the place, he had this symbol on his chest. And man, he got some criticism over that. They say that's a Nazi symbol. And so what he did is went in there and covered it up. And see, this is what it now looks like. And he posted all over the place. This was apparently something called a Totenkopf SS tattoo that the ADL says is connected to the Nazis, and a skull and bone symbol that they used. And so now he's covered it up, and he went over there and had a full photo session with people over in Maine. This is from the WGME, 13 on your side. And he covered it up. This is what the new photo looks like. So you can see right there, more nipples. So it went from a skull and bones into, I think that's Wilson from Castaway. I think it's Wilson with a wolf or a serpent or a demon or something. But it's like Wilson, remember, from Castaway with Tom Hanks. And when this photo dropped, everybody looked over here to this other tattoo. And I don't know what this symbol says or what that means, but this over here, 1919. The internet instantly noticed that, and they said, well, that's concerning, because what we have here, 1919, according to Avi Bitterman, MD, he said it's good that he covered up his first Nazi tattoo because this photo shoot reveals a second Nazi tattoo. 1919 is used to signify the SS. The S is the 19th letter in the alphabet. If he covers up that one too, will we see a 420 tattoo somewhere else? I don't know. But 1919 is now the subject of a lot of conversation. But the photographer came out and said, I invited him back, okay, from WGME. And they said, it's actually from the Trail Forest Crew. And that began in 1919, okay, the Trail Forest Crew. So maybe he's a Nazi. Maybe it's SS, or maybe it's that crew. I don't know, but they wouldn't give any Republican the benefit of the doubt. So we'll just say it's more in line with his other Nazi symbol, now his Wilson volleyball. But in addition to that, we have now found out that this guy is just a communist, a bona fide communist, Nazi or not a Nazi, whatever. He makes an admission, and CNN had a whole article about this saying, I got older, this guy right here, and I became a communist, which is just perfect for the Democratic Party. They went through over on CNN and then dumped this whole thing behind the paywall so nobody could read it. And they shared this. Graham Plattner, a veteran turned oyster farmer, is now a rising Democrat candidate in Maine, trying to kick out Susan Collins. But actually, he once called himself a communist. He dismissed all police as bastards and said rural white Americans actually are racist and stupid. Those are all according to self-deleted social media posts that K-File and CNN got their hands on. Now, most of the posts were made 5 years ago under Plattner's then Reddit handle called P. Hustle. They were deleted ahead of his campaign in August. The post in some ways underscore his reputation as an anti-establishment outsider. I know the left will love all of those views. Unapologetically left-wing. But the labels and tone could prove costly in a state known for electing moderates like Susan Collins, who's a very squishy Republican. In an interview on Tuesday, Plattner disavowed his post. He said, they came from a time when I was disillusioned and angry, and I expressed those emotions online. And my criticism of rural white Americans and the police and my political comments, they don't reflect who I am and what I stand for today. That was very much me effing around on the internet. I don't want people to see me for who I was in my worst internet comment, or even frankly, who I was in my best internet comment. I don't think any of that is indicative of who I am today, really. He said, well, he deleted the post because he no longer wanted to be associated with those comments. In one now deleted Reddit comment from 21, he responded to a thread about people becoming more conservative as they age. He says, I got older and I became a communist. Perfect for the Democrats because they got a lot of those. Here's one. Right here. I got older and became a communist. He says, absolutely. I'm a vegetable growing, psychedelic taking socialist these days. After the war, I've pretty much stopped believing in any of the patriotic nonsense that got me there in the first place. I can understand that. Yeah, I don't know that. I mean, many of us got duped into that. I obviously did not serve, but yeah, George Bush and the neocons and all of that, totally deflating. I mean, it's like, wow, what a joke that was. And am a firm believer that the best thing a person can do is help their neighbors and live a loving life. Well, unfortunately, communism and socialism results in dead neighbors. Still got the guns, though. I don't trust the fascists to act politely. We can do shoot them in the neck. So here's more. It continues. In another Reddit post, he reflected on his life after being a psychedelic vegetable lover. And in an interview, he wanted to assure voters, I'm not a communist, okay? I'm not a socialist. I own a small business. I'm a Marine Corps veteran. Yeah, flip that switch when you're running for a campaign. Just turn that one on. He entered the race in August to challenge Susan Collins, saying he's not fooled by this fake charade of Collins on his deliberation and moderation. He's running to fight for the working people, topple the oligarchy that's destroying our country. The primary field includes Janet Mills, 77-year-old governor. She's running. He's a former Marine infantryman, served in the National Guard, and has brought in a bunch of money, a lot of momentum. Honestly, I think this is just going to help him with his party. Some of his harshest critics and criticism was directed at law enforcement after George Floyd. Yep, go figure. Here you go. I have asked, and I do mean this in the most charitable of ways, but are you R-word? CMP has Mainers every chance it gets, so there's no love lost. And he's talking about the body cam footage somewhere else. Anybody who has even a modicum of time around guns as part of their living knows this. I knew there was no such thing as accidental discharge. He says, F these cops. He said, bastards. Cops are bastards. In a thread about a black Army lieutenant who was held at gunpoint and pepper sprayed by police during a traffic stop, he said all of them, in fact. Someone else said that they're bastards. He says all of them, in fact. All the cops are bastards. Great. So Plattner also frequently weighed in on the police violations, arguing misconduct was a problem. And he also wrote, F these cops. So the list goes on. He can say it was just me being an a-hole on the internet. I have an immense amount of friends who are police officers. They're not all bastards because they're literally buddies of mine. Then deleted all the posts. He said, well, actually, white people aren't racist. He says, living in white rural America, I'm afraid to tell you they actually are. White people aren't as racist or as stupid as Trump thinks, but he says, actually, they are. That's nice. When asked about the comment, he said, I don't recall that exchange, but it was just an argument. He says, I'm also a white guy, and I don't think I'm a racist. I don't believe that. I'm sure I was just angry on the internet about the state of things back then. I have to ask, and I do mean this in the most charitable of ways, but we shouldn't have to eat the pain because you C's and Massachusetts couldn't act like adults. F off and die. Leave Maine out of your capitalist fantasies. He's a communist for sure. So the project had been a political flashpoint. 60% of voters opposed it. He calls people traitors, effing morons, a worthless pea. Yeah. He is also posting all over the place in Socialist RA, a self-described anti-capitalist left subreddit. He told CNN he no longer feels the same disillusionment now that he's running for office. I'm still very angry of all the wars I had to fight in. Man, I'm angry about those too. I absolutely love the place that I live. I love the people around me. And he's moderating aggressively to make it in and through the primaries. And so the Nazi tats, I think mostly explained and covered up, but we'll see what the constituents think about his communism and his disdain for rural white Americans. And he's doing the Democrat thing. He says, years ago, I got a skull and crossbones tattoo with my buddies in the Marine Corps. I'm appalled to learn that it closely resembled a Nazi symbol. I altered it yesterday into something that isn't deeply offensive to my core beliefs, the volleyball from Castaway. I am very sorry to all of you who had to contemplate a symbol of hate over the past 48 hours. I hope that those people can recover from contemplating the symbol of hate. Maybe they just changed what they were contemplating, but maybe they couldn't do that because their brains don't function. So they just sat around contemplating a symbol of hate for 48 hours. Now they're traumatized. So he took the tattoo off, but he's, from his own comments, a communist. And we doubt that that's changed at all because communism usually stays on forever. And hopefully it has changed, but based on those recent comments and his affiliation with Nazis, he might have a little dictatorial flair, and he's running for office in Maine. And so we'll see what happens there. Their party will absolutely love this. They'll say they have to balance this out. Well, Nazi tattoo, but communist socialist. What do? We know what they'll do. He's bending the knee, buckling to their criticisms, and so they'll support him. And maybe he'll win. We'll keep our eye on it, my friends. Thanks for joining and subscribing as we do. All right, my friends, let's see who is here and joining us on the day. If you are just getting here, quick recap on what we talked about. The Supreme Court now weighing in on whether or not, we just read this. I think we just read this one. Whether or not the Supreme Court is going to stay a lower court order that prevents Trump from deploying the National Guard to protect federal personnel and property. Now in the Supreme Court, Amy Coney Barrett's hands. Will they accept this? Will they issue a ruling? Will they issue an administrative stay? What's going to happen? We read through the documents, and we'll keep our eye on what comes out next. Then we talked about Bolton, his lawyer, who just is so terrible. He had to correct his motion that was filed under seal. Abby. And so we turned that into a giant problem because, and we read through the travel request before we went through some of the SEPA procedures that the DOJ is proposing in the Bolton prosecution. We heard from Christina Bobb, Trump's former lawyer, and this representative called Brandon Gill, explaining their take on the Bolton saga. Then lastly, we turned our attention to this guy, a Democrat communist Senate candidate called Graham Plattner, who apparently had a Nazi symbol on his chest. He took it off, so he must have been concerned enough about it that it was too close for comfort, and he nuked that thing. But we also then read through his prior Reddit comments where he said, I am a communist. I am a socialist. I hate rural white Americans, and all cops are bastards and all the things. And so it was a great stream. Thank you for being here. Thanks for the donos and the support. And now let's hear from you and see what you say about all of this and more. I see some great comments and some donos and some good stuff. So thanks for being here and for sending these in. I hope your week is just amazing. All right, let's see what we got cooking. We got some good comments and a couple of them starting like this. Yeah, this one. Starting like this. Shout out to our amazing mods and Memesmith, Donut and John saying, turns out I can't control the weather. Alexis, 3 more days. And this morning we had some thunder on the members only stream. It was thundering and raining. So hopefully we got it out of the system. Yep. 3 days and counting. Saturday's the big day. Coming up soon, baby. Thank you, John. Hey, what's up, Waldo? One new membo is coming in. What's up, Pro Say America? Cheeky fella received a gift membership by Waldo. Thank you, Waldo. Welcome aboard, Pro Say America, a.k.a. Cheeky Fellow. Mark Shaw. What's up, Mark Shaw? The JB for the Illinois governor equals Jelly Belly. Yeah, JB. I thought it was peanut butter and jelly. Pritzker, PB and J. Pritzker, JB. So it's kind of out of order, but PB&J, he kind of, resembles. Hey, Rick D. Per the Babylon Bee, they're reporting, President Trump has gotten his hands on an excavator and is heading to the Capitol. Oh, that's great. That's funny, man. They would just flip out. Put on a hard hat, get out there, knock a wall down. It's great. Hey, what's going on? Chubby Stubby. Prayers up. Oh, man. Man, sorry to hear this. Okay, Chubby Stubby's here. I don't typically do this, but if anyone has any spare time in faith, please say a prayer for my mother. Shout out to Chubby's mom. Her name is Colleen Scudmore. She stopped eating, lost severe weight, and my brothers haven't been able to get her to want to get out of her bed. We'll be heading to see her this weekend, but my brothers fear she might not have that long. It's hitting hard. Not sure I'll be able to stick out the stream. Thank you all. Chubby, prayers up, my man. Sorry to hear that your family's going through that, but we're going to send some good love and energy to your household and pray for your mother, Colleen Scudmore. May she make a great recovery and find the will and the energy to continue forward. But I am very grateful to hear that you're going to be able to be there with her and with your brothers and your family at this time. And we're going to send some prayers to you and your bros because, man, we love our mamas here. So I'm sorry to hear you're going through that. Thank you, Chubby, for the dono. My friends, prayers up for our friend Chubby and his mom, Colleen Scudmore, if you got him. Starch Manning. Can you turn in any of your Patriot or don't tread on me stuff since you don't care about federal overreach? Well, first of all, no, we're not turning in anything. We're going to keep it. Thank you. And we do care about federal overreach. So I'd like to know what you're asking about more specifically, Starch Manning. But no, we're keeping it. We are patriots, and we don't want our government treading on us at all. And we look good in it. But thank you for the dono. So maybe there's more context somewhere for what you're asking about. Marlene, Membos gave Rob... Oh, I see another comment. Membos gave Rob and Alex a shower of love and wisdom. From Marlene, 20 months as a Membo. Yes, Marlene. Thank you for that. We've got a lot of wisdom, man. And we have a lot of people with some really nice marriages, like long, loving marriages. Everybody's happy. They're like, I love my wife. I love my husband. I'm like, that's amazing. After 30 years, like it gets better. It's amazing. Yeah. Hey, G-Man, what's up? Why can Congress delegate their constitutional authority via statute, lacking a constitutional amendment? So I would say that the way the Constitution is framed, right, is Congress can make laws necessary to effectuate the things. So the president has the power to take care, and then the Congress has the power to effectuate laws that are necessary and proper for these things. So in other words, Congress can set the terms of it, which was my point. Like, if you don't like what Trump is doing or what he's delegating, Congress can just revise the statute and just say, actually, we're going to limit your ability to invoke the National Guard. You know, we're going to delegate these powers to you, and they have. We're going to set the terms, in other words. Like, Congress is not going to effectuate the laws. So if it's a National Guard law, the executive is still going to have to do that. But Congress sets the terms of it. So they're basically delegating and handing off that authority. So maybe delegating is not the right, the most descriptive phrase. It's more like they're setting the terms of what the executive can do. If they don't like it, they could always change those laws. But they know that if they set up certain things, it would be violative of the take care clause. It would be violative of the execution of the law. And it's a complex area because we talk a lot about this with the firings and these independent bodies and things. What is delegation? What can be delegated? You see it a lot. It's, you know, there's a whole concept in the law called non-delegation doctrine and how certain powers can be handed and other powers cannot. But I would just say, if you go right back to the Constitution, Article 1, Section 8, wherever that one is, the necessary and proper section. There's like 8 different, powers that are delineated there. So I would say that gives them the authority to set the terms, and then the executive branch carries out the law. And an amendment would be necessary to change that process. Great question. Starch Manning, follow up. Trump and Stephen Miller just classified Antifa as a terrorist organization. Is that new, like today, or is this what we've already talked about? And we all know they'll lie and use that to label protesters. This is tyranny. So maybe that's the government overreach. So by the way, yeah, like if Trump starts labeling people Antifa and just goes like arrests some, protester standing there with no evidence of crime or guilt as being a terrorist, then that would be a problem. But do we have anything like that that's popped up? In fact, I don't think the president is arresting as many people as he should. And do you say that Antifa is not a terrorist organization? What would you qualify a terrorist organization to be? My point would be that Antifa is trying to change policy and they're using physical violence to do it. And of course, they're not going to identify them and take credit for those things, because that is the opposite of the strategy. Terrorists and terrorist cells want to operate in the shadows. So they're not wearing, they actually are wearing identifiable gear, but they're not claiming to be a part of a nation state. So if you have a group of people who are organizing and committing violence in order to change policy at scale over months and months and months, you've got a financial network, you've got funding, you've got safe houses, you've got basically complicity from local police and federal conflicts in enforcing the law. They'll defend them. What would you call it? Is it not a terrorist organization that's trying to attack in order to change policy? It seems like it is a terrorist organization. And remember what Joe Biden did is every single quarter, we got a new classification from the FBI. You remember this. Racially motivated violent extremists. Remember that? And then the next one, religiously motivated violent extremists. And they just passed every quarter some stupid new thing. Homegrown domestic violent extremists. If you were patriotic, if you wore a symbol, if you wore a "Don't Tread on Me," they were coming after you for that. And they would just label you an extreme MAGA protester. And, I'm not seeing Trump do that. We call them, communist lunatics, but we're talking about the communist lunatics. And Antifa is a subset of the lunatics who are engaging in violence in order to change the policy. So if there is government overreach, I'll certainly call it out. But arresting the people who are acting in a terroristic fashion is is patriotic. We don't want our country taken over by terrorists or terrorist adjacent groups. Here's some other comments. Yeah, these are violent activists. Just keep paying to post nonsense, says Chris. Gerald says they're allowed to deem them terrorists. They're trying to stop federal law from being enforced. This is actually an insurrection. Yeah, Antifa is a terrorist organization. Safe Guy says exactly. Trump's a crook and a clown for wanting to enforce federal law to deport people who he has lawful authority to deport. Yeah, all right. Rubos, what's up, the Rubos? Thank you from the Rubos. Man, look at that post. Golly. Treasury sanctions major Russian oil companies, calls on Moscow to immediately agree to a ceasefire. That's a big post right there. Let's see if we can just see what the highlight is. No, we can't see it. But yeah, that's a big post. Trump's like, see, I'm not playing around. Look at this. It's 15 pages. Read it, Pootie. Thank you, Rubos. G-Man is here. The Marbury versus Madison decision is looking worse and worse every day, Rob. And G-Man is in opposition to Marbury versus Madison, I think is what the winky face is for, which is about judicial review. And there's arguments, that judicial review is just kind of made up by the court to give them power that they don't actually have, and they don't even have that power. And there's some truth to it. I mean, the Supreme Court was kind of an afterthought in many ways. Like, they didn't even have the Supreme Court building, I think, until the 1940s. They used to work in like congressional offices, like next door to Congress. Before that, they were in New York, like at the New York Stock Exchange kind of thing. And then Marbury versus Madison came around, and then kind of judicial review was invented in a really weird case that was all full of conflicts and stuff. But the Supreme Court judges just cherish it. Ask John Roberts about Marbury versus Madison. I'll talk your ears off. Hey, Dome. I doubt Amy Coney Barrett fumbles this ball despite John Roberts in her ear. Yeah, I don't know. We'll see what Amy does on this. We'll see if they want to condone ongoing violence and limit the executive from deploying people when there's consistent attacks on federal agents. Hey, Mizzy M. Sending you best wishes for a beautiful wedding and a wonderful life with your new bride. Thank you, Mizzy M. Very nice of you to say that. Yeah, the clock is ticking away, coming up soon this weekend. Thank you for that. Hey, the Rubos also celebrating. In less than 72 hours, wedding bells will ring. And Rob and Alexis will exchange their vows for a lifetime of love and union. That's true. In celebration of their marriage, we are delighted to offer to the Watcher family this exclusive 35% discount for a 2-pack of our premium Rubos salt, the best salt you've ever had in your whole life. It's from the oceans of France. Fleur de Sel, number 9. Visit rubosaltshop.com. Use code WTW35 at checkout. And God bless you all. It's great. It's great. Man, $19.50 plus shipping. rubosaltshop.com. Man, thank you guys. The Rubos, you're amazing. Get your salt. We love it. Yeah, we love it. And so does my mama. Hey, Biltong is here. Biltong, King of Biltong. What a nice dono. Thank you, King of Biltong. You know where to go. BiltongUSA.com. Use promo code Robert. You get some Biltong candy, amazing snacks and goodies. Robert, I wish you and the missus a long and prosperous life together. May every year bring you more success than the previous. Congratulations, King of Biltong. What a nice comment, my man. Thank you for the nice dono. And for helping to defray the wedding costs. Very nice of you. I appreciate it. Thank you, everybody, for doing that. Yeah, so amazing. Thank you, King of Biltong. You know where to go. Biltong USA. Great to have you, Biltong. Thanks for the very nice dono. Very cool of you. Waldo, bringing in one membo. C. Warren is coming in. And we'll see you in the after party. C. Warren, coming up soon. And thank you for that, Waldo. Hey, this one from Cardinal O'Flanagan. Worse, they were actually dispatched en route and they were ordered to turn away. To not respond to the scene or even stage, it was directly clarified by dispatch. Wild. Yeah, so they're doing the opposite of helping, which is not good. They're saying, we will be there to help, and then when they're called, they're not there. It's like a betrayal. You're going to catch me if I fall, right? And they don't catch you. Sam in Texas, 16 months as a membo, says, at this rate, Trump will have a 50-0 SCOTUS record. He's doing pretty well in SCOTUS. There were a couple weird decisions, like that one when Amy came back down and they scolded that judge out of Texas who did everything right. But Otherwise, it's been pretty good, Sam in Texas. Hey, Mark Shaw. Nice to have you, Mark. DJT should start his own form of lawfare by pursuing TROs and PIs against sanctuary states and cities. So he is, actually, for harboring, aiding, and abetting illegal aliens in violation of federal immigration law. No taxpayer funds to illegals. Yeah, and so Pam Bondi has filed and has sued a bunch of these sanctuary states. Haven't had the same success. Much easier for these federal judges to stop Trump than to, like one example is, I think, Harmeet Dillon is suing in some county in California. We covered it here, where they're demanding their voter registration lists. They have to update their lists. We don't want illegal aliens on there. They have to keep them maintained under federal law and disclose them, and they're not. So they're suing kind of at the ancillary policy decisions of the sanctuary state. So like pick a reason to sue, go sue to clean it up. Mark Shaw, thank you for the nice dono. And thanks for being number one in the chat. We appreciate you. We got ELZ. Thank you, Rob. Your insightful dissemination of these court documents are why I'm here. That and the chat and the memes. Yeah, the chat and the memes are way better than any alleged insight I have. But we do read documents. We are the humble document reader. We do a lot of that. Sometimes better than other days. What's up, FD man? Fascism and communism have a single seed, which is democratic socialism. Both turn into murderous dictatorships. Proponents of eugenics, allowing them to dehumanize the less than pure, and both are godless. It's a great comment, FD man. Yeah, really good one. It's true, they're kind of both sides of the same coin. They want a dictatorial governance, ultimately. The communists would disavow that. The communists just like, they don't like to label themselves. They want to get away with all the classes and, have just this nice utopia with no government, which has never, ever worked in practice. And so ultimately you get these two dictatorships that just mature, and it's disgusting, both of them. James Kipp, solution for this issue is to create HOA Alcatraz. Homeland buys up homes in gated sanctuary cities, and they can house MS-13 TDA gangbangers next door to lefty judges and politicians. Yeah, let them out. They can just sell their drugs from their neighborhoods. And isn't that their standard? The AG said the only way that you have policy changes is if, you can experience it. So it would just be like them getting familiar with the people who are in their cities. Not that we want anything bad to happen to anybody. We don't. We're not Democrats. Don't. Bolton is going to try to smuggle tomahawks in his mustache and sneak him out of America. I probably will. Hopefully Homeland puts him through a metal detector. FD man. Even Bolton's lawyer doesn't know how to make documents confidential. Bolton can't even keep a doc secret. Just taste of things to come for a cigarette person. Alana Noble. Whenever Pritzker mentions Hitler to compare when Trump requests the NG, my blood boils. My parents were in Germany during World War II. I can honestly tell you it's not the same. And my parents are German. Yeah, it's just a weird thing to see people so upset about just standard enforcement of the law. And I guess they want to breach that law because they just want their policies to happen regardless of the law. It's like, well, that's not how our country works. You actually have to have laws and governance. So it's a false equivalency. And I think it unnecessarily riles people up and exacerbates the violence. They're free to do that, but it's not even a good comparison. It's like, okay, what is Trump doing? Is he going to commit a mass genocide of all the illegal aliens? Is there any evidence of that at all? Larry, judges forced a fast track to get conviction before the election. Can you do a parallel timeline of Bolton's case compared to Trump to see how the judge's bias is and how they handle the two cases? Yeah, certainly. I mean, that's going to be a running theme, Larry. Totally. For both Comey, Tish, because like it's beautiful. It's almost poetic. Tish goes after Trump for fraud. Ultimately is losing that. She got a $500 million judgment. That's evaporated. The judgment stands, but it's evaporated. No real penalty or damages. Now she's getting investigated for fraud. Bolton screeched and shouted about classified documents. getting prosecuted for classified documents. So we get to see how things were handled against Trump, and we can make beautiful comparisons in these future prosecutions. Hey, here's Rick D. John Bolton's mustache is agreeing to testify him in exchange for immunity. And that mustache has been through it. You can see how gray it is. Yeah. It used to be brown. Not anymore. Because of everything that mustache has seen. Hey, what's going on? Milo phone bill. Retaining and distributing top secret and TSI documents is very serious. Who cares if he was writing a book? Yeah. Well, the DOJ doesn't. In his case, he had 18 counts, and they probably could have hit his wife and daughter with stuff, and they didn't. They just got after him. They didn't even talk about anything in the book. It was the bad stuff. Yeah, it was the bad stuff. Hey, Coyote. What's up, Coyote? Thank you for being a membo. Welcome aboard. Membos, stick around on YouTube. You should automatically be transitioned to our after party when that's coming up. Ospac, what's up? Okay, so do I have this correct? He enlists in the Army, has Marine buddies, and yet none of them had enough history learning to understand that the Totenkopf was a key Nazi image. I don't know if he is that stupid or he's hoping his voters are. I don't know. Yeah, and we looked at some other like skull and bones this morning. We looked at the Yale skull and bones, and I think they have the femur going this direction. And, you know, tattoos kind of get blurry, and we had some other comments this morning about that. And he didn't think it was a Nazi symbol. And apparently he was in the Army after the Marines, and so he had his body checked, and they didn't think it was a Nazi symbol. So a part of me thought he should just own it. It's not a Nazi symbol. It's a tattoo that I got with my bros. Like, what do you think? What do his Marine bros all say? Like, do they think it was Nazis? You just own it. You had it on your body for 20 years. You just say it's not a Nazi symbol. I'm not a Nazi. I'm a communist. But then he goes and turns it into a Wilson volleyball, which is just even weirder. He was dancing naked at his sister's wedding or something. Hey, Just Rhonda. Have a great wedding weekend. Rob, Alexis, and Puppy, Heart, and Dove. What a nice comment. Thank you, Just Rhonda. 19 months as a memo, 2 babies, and then some. We're excited about it. It's coming up soon, man. Hey, Ospac. By the way, Rob, I'm just some poor graduate of the West Point of Australia, and I still know what the image means. Yeah, and we also saw a comment from Meghan McCain. She's like, I've got tattoos. I know what every one of them means. I've gotten tattoos when I was drunk, and I knew what they mean. Plus, prayers up for Chubby's mom. Thank you, Ospac, for saying that. Yeah, prayers up for Chubby and his fam. FD man. Who loves these words from leftists? Quote, we all know, or as you know. Those are propagandist buzzwords, cheap and lazy debate style. What do we all know, loser? What is your point? It's a low IQ tactic. Yeah, I think that's exactly right. And it's sort of presuming your conclusion, which makes it so you don't actually have to prove your conclusion. You just say everybody knows. It's kind of an appeal to authority, which is the common knowledge. Not very sophisticated. FD man, what's up? SCOTUS justices had only 2 secret requirements. 1, have red hair. 2, be a stepchild, but that ended when the fairy godmother made the courthouse in D.C. That's interesting history. I have to read more about that. John Cena, what's up? In the house. Good to have you, John. Thank you for the nice dono. We appreciate that. No comment on it, but very nice of you to send that in and support us. We appreciate you, John. Thanks for being here. Albert the Marine, what's up, Albert? Trump should threaten to pack the Supreme Court unless there's a constitutional convention to limit the court to 9 members. Well, so there are 9 members right now. And why would he want to pack it? I mean, the court already is 6-3 to Republicans. So I think the Democrats wanted to pack it. They wanted to add another 3. So the court is in our favor. So I think if he actually tried to do that, then people would say, why is he doing that? And that might actually cause some more political blowback. But interesting concept. There are 9 members right now. So you've already won, Albert the Marine. Congratulations. It's happened. Amazing for us. Thank you for the dono and for the comment. All right, let's say what's up to our friends over on X. And then we're going to have an after party. YouTube friends, hang tight. It should navigate you right over there. No problem. All auto magically. James Pepper, if your cousin shows up to your wedding with the Witch of Salem, just roll with it. I don't even know what that is, but we will. Rob, make sure this doesn't happen in your wedding. Another one from Hugo and Alice's wedding day. Thank you, James. A couple great comments over there. My friends, thank you for being here. Thank you for the awesome donos and for being here, supporting our channel with your subscribe, your likes, with a share. Thanks for sending it over to a friend or family member so that they can join us when we come back tomorrow, which we will. Now, before we wrap it up, big thanks to our amazing mods and meme smiths. Thank you to John, to Donut Mind Me, to Carrie B, to K Bean, modding for us. Our friends, Janek, Dog Digger, Neuro D in the house, Jigum, Elliot, and Just Rhonda. Keeping things nice and beautiful and orderly around here. But we're going to pause here for the evening. It's a beautiful Wednesday. We're coming back tomorrow, my friends. And we want to see you here because in order to do the show appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers, shining the light. Watching the watchers, defending what's right. Watching the watchers, stay each night together and live.